All right, welcome everybody. I'm very excited about today's program. I think it's going to be an excellent and educative experience for all of us. I am Larry Rosenthal. I am the director of the Center for Right-Wing Studies here at in this building at the University of California. We have several co-sponsors for today's event. They include the Charles and Louise Travers Department of Political Science, the Center for the Study of Law and Society, and the Center for Research on Social Change. Before we get going seriously, a couple of announcements. One is that on Thursday, March 12th, in this room, our center is presenting an event which will feature Albert Bergeson, who is a professor of sociology at the University of Arizona, and he will talk on the roots of jihadism. That talk will be from 4 to 5:30 here in the Wildavsky room.
What's that date again?
March 12th. And I would ask people to take a moment to make sure their cell phones are off. And with that, we're ready to proceed to introduce today's speaker. Today's speaker is Amanda Hollis-Brusky. Amanda is the assistant professor of politics at Pomona College, and she teaches courses in constitutional law, legal institutions, and American politics. We have a particular pleasure in Amanda's presence here, as she is a product of UC Berkeley, where she got her MA and her PhD from the political science department. And she has written on the conservative legal movement, the Christian lawyering movement, originalism, executive power. Her articles have appeared in journals such as Law and Social Inquiry, Studies in Law, Politics, and Society. She's also written about the Supreme Court for the Washington Post, The Life of the Law, and the Oxford University Press blog. The talk she will give today, may I?
You may.
Will be about her new book, which is Ideas with Consequences, which is about the Federalist Society and the conservative counter-revolution. It's published quite recently by Oxford University Press and is in fact based on the dissertation she wrote here at UC Berkeley. When I first thought, okay, we're going to do a piece on the Federalist Society, the phrase came through my mind, the real vast right-wing conspiracy, but I'm trying to suppress that. We won't go there. But I think this is as important an organization to understand in terms of the right-wing ascendancy that we've experienced over the last several decades as any group we can talk about. I also would like to introduce our respondent. Our respondent is Fred Smith, who is an assistant professor of law, having joined the UC Berkeley faculty, law school faculty, in 2010. He is a scholar of the judiciary and of constitutional law. He received in 2004 a BA with honors from Harvard College. His thesis was awarded magna cum laude. He then obtained a JD from Stanford University in 2007, where he was a member of the Supreme Court Litigation Clinic and served as president of the Black Law Students Association. He also served as articles editor for the Stanford Law and Policy Review. Fred Smith's research focuses on state sovereignty and representative government, and his work has appeared in the NYU Law Review, Stanford Law Review, and Fordham Law Review. So, if you would, please join me in presenting our two speakers. First, Amanda Hollis-Brewski.
Thank you. Thank you, Larry, for that kind introduction. It's great to be back in Berkeley, and it's also great to have my dissertation advisor, Bob Kagan, in the room, and Roseanne Greenspan, who gave me a home as a homeless postdoc after I finished my dissertation here and before I took my job at Pomona College. So as Larry mentioned, this afternoon I'll be talking about my hot off the presses, just released book with Oxford University Press called Ideas with Consequences. But before I get into the talk itself, I want to give you a sense of how the project fits into a broader agenda that reflects my interests within the fields of law and American politics more generally. So in general, I'm interested in the question of how civic actors influence policymaking in the institutions of American government. Political science has provided us with a fairly comprehensive set of insights into the pathways of civic influence into the political branches of government, Congress and the executive branch. We have an understanding of interest groups, lobbyists, and how these groups use resources and relationships in Washington to influence the policymaking process. We know far less, however, about the pathways of influence into the judicial branch, what founding father Alexander Hamilton famously referred to in Federalist 78 as the least dangerous branch of government, the branch whose officers were meant to be independent, free from political influence, unaffected by public opinion, and resistant to capture by groups of elite minorities. After all, as Hamilton insisted, these were the only conditions under which judges and justices could properly carry out their duties as guardians of the Constitution. While judges and justices certainly work hard to maintain the trappings of independence, for instance, they go to work in a giant marble temple, they deliberate in secret, right? They emerge from behind a velvet curtain to deliver their rulings in rather dramatic fashion. But underneath those black robes are men and women with political beliefs, civic and religious affiliations, friends and family with varied interests. For instance, we know at least one Supreme Court justice likes to hunt ducks with Dick Cheney, though probably not so much anymore. Some had political careers prior to becoming judges, others were practicing attorneys. And without exception, they were all trained professionally as lawyers first. So my work on the Federal Society for Law and Public Policy Studies provides one set of insights into how these personal and professional connections to life outside the marble temple can translate into avenues of influence for groups of civic actors looking to shape the outcome of Supreme Court decision-making. But first things first, what is the Federal Society? So the Federal Society was founded in 1982 by a small group of conservative and libertarian law students at Yale and the University of Chicago. Several of these founding members had worked on the Reagan presidential campaign before coming to law school, and they noticed a profound mismatch between the ideas that were achieving political ascendancy at the time, ideas about free markets and limited government and states' rights, and the ideas that were being represented on their elite law school campuses, which were, and by and large still are, left of center. So as many of the founding generation expressed to me in interviews, their professors were dismissive and even openly hostile to conservative and libertarian ideas. As a response, this small group of students organized a conference in the spring of 1982 at Yale Law School. And they brought all of the leading lights of the conservative and libertarian legal movement of the time to their campus to debate their professors. So these were figures like Robert Bork, Richard Epstein, Milton Friedman, then Professor Antonin Scalia, Charles Fried, and others. So the proceedings of this very first Federal Society meeting were then reported on in the National Review magazine, and they generated a huge response from students and faculty across the country, wondering, hey, how can we set up our own chapters of the Federal Society? Unbeknownst to them at the time, the founders of the Federal Society had tapped into a high-demand market. Fast forward 30 years. The Federal Society now has student chapters at every law school, lawyers' chapters in every major city, a portfolio of practice groups organized around issue area, a faculty division that acts as a conservative and libertarian counterpoint to the AALS, a national headquarters in Washington, D.C. with a full-time executive staff, and an annual operating budget of over $6 million. Its conservative and libertarian legal network extends to all levels of the legal community: law students, academics, practicing lawyers, federal and state judges, legislators, executive branch officials, media types. Among its 40,000 plus members, the Federal Society can count every Republican-appointed Attorney General since its inception, every Republican-appointed Solicitor General since its inception, dozens of sitting federal judges, and 4 current sitting Supreme Court justices. You can probably guess which ones they are. Antonin Scalia, who was actually the very first faculty advisor to the Federal Society when it was founded at the University of Chicago. Clarence Thomas, who is, as many of my interviewees described him, the closest thing to the pure Federal Society model. Chief Justice John Roberts and Samuel Alito, both of whom kind of grew up professionally within the Federal Society, came up through its ranks. Now, because of the scope and reach of its network, and because of the prominence of many of its members, the Federal Society has been referred to by journalists as the conservative cabal that's taking over America, or as Larry described it, a vast right-wing conspiracy. But while those on the left and the right both agree that the Federal Society is an important and influential organization, it does not exert its power in a way that's easily recognizable to students and observers of American politics. It is a self-professed society of ideas. As such, it doesn't lobby like an interest group. It doesn't finance and bring litigation like a public interest law firm. It doesn't participate in litigation as a friend of the court, or amici curiae. It doesn't officially endorse judicial or political candidates. And it doesn't publish position papers like a think tank. So while the Federal Society as an organization doesn't do any of this, its members do all of this, right? What the Federal Society as an organization does do is intellectually train, educate, and socialize its members through its various meetings, programming, and networking events, and then encourage its members to draw on this training as they go about their work as lawyers, judges, clerks, policymakers, academics, etc. So I think this quote from Federal Society founder David McIntosh succinctly captures the kind of influence that the Federal Society has. So as McIntosh said in our interview in 2008, when I asked him about the Federal Society's influence, he said, "The Federal Society has trained now 2 generations of lawyers who are active around the country as civic leaders. Implicit in that is the Tocquevillian notion of lawyers being important for the community and society. And so that's going to be untold ways in which notions of originalism, of limited government, of the rule of law are being implemented in thousands of decisions at various levels of government and the community outside of government. Putting them in place means we'll have 50 years of seeing what that actually means for impact." So the McIntosh quote starts to get at the question of how exactly the Federal Society exerts its influence, right? Some of these untold ways that its members are influencing decisions at every level of government. And really the project of Ideas with Consequences was to try to start to tease out in a social scientific way some of these untold ways, to try to see if we could understand this influence. How did I do that? Well, this is the jargony part of the talk, so bear with me. We'll get past it, I promise. McIntosh's description of what the Federal Society Network is and what it does bears a strong resemblance to what scholars of international relations have referred to as an epistemic community. To save syllables from here on in, I'll refer to it as an EC. A close cousin of Thomas Kuhn's concept of a scientific paradigm, in Ludwig Fleck's idea of a thought collective, an EC has been defined as a network of professionals with expertise in a particular policy area, bound together by a shared set of normative and principled beliefs, shared causal beliefs, shared notions of validity, and a common policy enterprise, who actively work to translate these beliefs into policy. So the logic of the EC model, as it's been deployed in international relations, is pretty straightforward. As decision makers face an increasing number of difficult or complex policy decisions, they'll tend to seek support from experts as sources of authoritative knowledge. This opens the door for well-coordinated groups of knowledgeable experts with formal or informal ties to decision makers to frame, filter, or shape the outcome of the decision-making process. In this way, ECs can be understood, and I quote from Peter Haas here, as channels through which new ideas circulate from societies to governments, with their individual members acting as cognitive baggage handlers, I love that expression, whose activities and movements inside and outside of government make that transmission possible. So if we import this logic right, from international relations, and we apply it to the American judicial enterprise, we can start to see that there are some institutional and political characteristics that might facilitate inroads for networks like this to have influence on the judicial policy-making process. To carry out their work, legal and judicial decision makers often rely on the broader legal community for intellectual support. This is particularly so in the case of judicial decision makers, whose written opinions and decisions need to persuade legal elites, and through them, the public at large, to be considered authoritative. Our very own Berkeley scholar, Martin Shapiro, famously referred to this as the giving reasons requirement. Right? So unlike legislators who simply vote yay or nay according to their policy preferences, judges and justices have to give reasons. They're required to issue written opinions explaining, supporting, and defending their decisions in the language of the law. In order to persuade us that their decisions are legitimate, these opinions must situate the decision within a line of established precedent. Right? So the court has to say, what we're doing here is consistent with what courts have done for 150 years. And we're going to cite various decisions to show this. If they can't do that, if they want to do something different, right, they have to provide a convincing argument for why those previous decisions, that previous framework, should be ignored, altered, or reconstructed entirely. As I've argued in my previous work, the importance of this persuasive function of the court is heightened in cases where the Supreme Court is altering or reconstructing existing constitutional frameworks. All right, so I use this term doctrinal distance. Cases where doctrinal distance is great, where the court takes a big step away from its established precedent, its established doctrine. This is a key point, and I want to return to it when I discuss the case selection for the book. But now I have to convince you why, if the epistemic community framework kind of fit, but not perfectly, it was necessary to innovate a new concept. A political epistemic network. It just sounds better. PEN. It rolls off the tongue. The short answer to this, by the way, is because the reviewer said so. But I'm also going to try to persuade you that it's a useful concept for understanding communities like this within the legal political context. Okay, so structurally, an epistemic community, what we just discussed, and what I'm calling a political epistemic network, a PEN, look nearly identical, right? They're both interconnected network of experts with policy-relevant knowledge who share certain beliefs and work to actively transmit those beliefs into policy. The primary distinctions to be drawn between an EC and a PEN have to do with the kinds of knowledge networks that each concept seeks to model. So with the EC, these are mostly scientific or technocratic networks, versus with the PEN, legal and constitutional. Well, why does that make a difference? Law is not like science. Lawyers and judges are not like technocrats. Claims to legal knowledge are non-refutable. They're always politically contested, and they depend more on the authority and power of the speaker and the speaker's institutional position than they do on some kind of objective truth, right? A scientific or technocratic EC can be proven wrong empirically, and their knowledge claims refuted. So as Peter Haas writes in his seminal theoretical article, if confronted with anomalies that undermine their causal beliefs, ECs would withdraw from the policy debate, unlike interest groups. Think about public policy health advocates, right? They're not interest groups. They have strong causal beliefs that there's some action that the government's taking that could either protect people or harm people, right? If there was evidence to show them that they were actually wrong about that, right, that their beliefs were unfounded, that there was some objective way in which they were disproved, they wouldn't keep lobbying. They'd withdraw from the policy debate. So that's the primary distinction that Haas is drawing between interest groups and epistemic communities, okay? But this isn't the case with a PEN, whose knowledge claims and authority are derived from contested interpretations of political texts and meanings, such as those found in the Constitution. A PEN can temporarily be displaced and rendered powerless by the emergence of a rival PEN, whose members more effectively infiltrate positions of political power and decision-making. But that PEN can continue to contest from the outside, right? Working to better adapt, legitimate, and market its own knowledge claims while still trying to place its people into positions of power and influence. So I think this is a key distinction of why the Federal Society Network needed a new model, right? It's not exactly like an epistemic community. This also means that PENs can and do modify their beliefs so as to better achieve their goals. And this is another important distinction. So beliefs in the Penn model here should be understood as strategic and instrumental rather than sincere and objectively grounded, as they are often characterized in the EC model. One example of this is, so many of you may remember that the left used to talk about the living Constitution, right? And the living Constitution used to be seen as a good thing. We don't want a dead Constitution. We want our Constitution living, breathing, adapting. The right so effectively killed that no one on the left talks about a living Constitution anymore. That doesn't mean living constitutionalists receded from the policy debate, but they're reframing their arguments. If you talk to Goodwin Liu and Pam Carlin, it's constitutional fidelity. If you talk to Jack Balkin, it's living originalism in some very confusing way. Okay? So this is the difference between a Penn and an EC. All right? So we're going to stick with the Penn. Okay, all that being said, the techniques for demonstrating Penn influence are identical to those for demonstrating EC influence. And as Peter Haas has written, they are straightforward but painstaking. And I can actually attest to the painstaking part of that. Here are the steps. First, you identify network membership. Second, you determine the shared principled and causal beliefs that bind the network together. Third, you trace their activities. And four, you demonstrate their influence on decision makers at various points in time. And I'm happy to walk through in great detail how I went through all of these steps in the Q&A if you want. But for now, let me get to the fun part. Okay, so this is how I applied the Penn model to the Supreme Court in the cases that I examine. So as you'll see here, this is the Federal Society Network. Okay? The dotted lines represent members of the Federal Society Network, right, going to work, right, as legal professionals and acting as cognitive baggage handlers. So they're carrying the ideas and the beliefs of the Federal Society Network into their capacities as academics, lower court federal judges, litigators, friends of the court, Supreme Court justices, or their clerks. Okay? The solid lines represent means of transmission of those ideas. So what do I mean by that? So ideas might be transmitted by a lower court opinion written by a Federal Society affiliated judge and then appealed up to the Supreme Court. Ideas might be transmitted through published scholarship, law reviews, or books, and then picked up by a Supreme Court justice or his or her clerk. Ideas can be transmitted through briefs filed by litigators in the case, or by briefs filed by friends of the court. These are people who are not of counsel in the case, but feel like they have something to offer, some kind of information that will be helpful for the justices as they try to decide the case. And this is really the primary mechanism, amici curiae, for people to lobby the court, right? Okay. So this is the model, right? This is what a political epistemic network looks like, and I mobilized this model and applied it to revolutionary Supreme Court cases in the areas of campaign finance, the Second Amendment, federalism, and state sovereignty. So in my previous work on the Federal Society, in my dissertation that was then published as an article, I had found that, consistent with the logic I outlined earlier, the degree of idea diffusion from the Federal Society Network to the Supreme Court was highest in cases where the Supreme Court took a big step away from its established constitutional doctrine, right? These big step cases. Again, this makes sense. The Supreme Court can't simply say, the Constitution, whose words haven't changed, meant A yesterday but B today because we say so. And they can't certainly rely on the previous decisions of the Supreme Court. So they have to look outside the marble temple. They start importing these authorities, external authorities, to help them rebuild constitutional frameworks. So given that, in this book, I test that finding with reference to a broader array of cases, okay? And these cases were selected because of the distinct conservative turn each has taken over the past 30 years, and also because unlike the various issues that tend to divide the conservative coalition, and I think we all know what these are: abortion, the NSA, national security, regulation of drugs. These are issues on which there appears to be, if not 100% agreement, at least a pretty broad and identifiable consensus within the Federal Society Network. So in each of these cases, I track who from the Federal Society Network is participating and in what capacity. And then I examine the extent to which the Supreme Court opinion in that case reflects the transmitted ideas or intellectual capital of the Federal Society network. Right? If any of you are on the faculty here, it's kind of like looking for plagiarism in student papers, right? It's a very similar process. Okay, so what did this look like in practice? Let me give you an example from a 2008 case called the District of Columbia versus Heller. This was a gun rights case, a Second Amendment case, in which a 5-justice conservative majority on the Supreme Court ruled for the first time in history that the Second Amendment protects an individual right, not just a collective right, to bear arms. The practical effect of this decision has been to make gun regulation more difficult to pass, as it affords greater and more robust protections for gun owners. So here we have our Penn model applied to Heller. Again, remember these dotted lines represent Federal Society Network members, sort of moving into their capacity as legal professionals and participating in this case in some capacity. In this case, I was able to identify 32 key members of the Federal Society Network participating in this litigation. All right, so lower court judge and Federal Society stalwart Lawrence Silberman wrote the D.C. Circuit Court of Appeals opinion in Heller, which was then appealed to and successfully heard by the Supreme Court. All 3 litigators who financed and orchestrated the litigation were also active members of the Federal Society Network: Clark Neely, Robert Levy, and Alan Gora. I also identified 21 Federal Society members on friend of the court briefs, these amicus curiae briefs here. Some of the more prominent members participating included Ted Cruz, now Senator, then State Attorney General, Robert Bork, the late conservative intellectual, Edwin Meese III, Reagan's former Attorney General, Eugene Volokh, who runs the Volokh conspiracy and will actually factor very heavily into the Scalia's opinion here, and Charles J. Cooper, who was on the losing end of the California Prop 8 marriage equality litigation. So I've also identified, you see the clerk box here. Clerks, as political science literature has shown, and I'm sure Fred could tell us, play a big role in drafting and researching the court's opinions. And so they become very important conduits, right, for idea diffusion in cases like this. And then 4 Supreme Court justices, the 4 I identified earlier, Scalia, Thomas, Alito, and Chief Justice John Roberts. Okay, so former Federal Society mentor and advisor Antonin Scalia wrote the opinion for the conservative 5-justice majority in Heller. And in doing so, he relied heavily on intellectual capital transmitted by the Federal Society Network. Right? So interestingly, one of the keys to constructing the individual rights framework for the Second Amendment, to persuading everyone that we know we said the Second Amendment meant one thing for 150 years, but today it means something else. Right? One of the keys was to convince the reader that the Second Amendment was actually meant to be read backwards. Okay. That is that the emphasis should not be on the first half of the phrase, and you'll see it's down here, a well-regulated militia being necessary to the security of a free state. If we put the emphasis on the first half of the phrase, as courts did for 150 years, we would think that the right of the people to keep and bear arms is conditioned on a militia, on collective security. Right? Scalia said, no. It's actually, you have to read it backwards. So what you need to really focus on is the second half. The right of the people to keep and bear arms shall not be infringed. Okay, so how on earth is he going to plausibly convince all of us that the framers intended for us to read the Second Amendment backwards? Well, that's where a few pieces of intellectual capital from the Federal Society Network come in quite handy. So this is an excerpt from Scalia's majority opinion in Heller. All right? So he says, the Second Amendment is naturally divided into 2 parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but rather announces a purpose. The amendment could be rephrased, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Although the structure of the Second Amendment is unique in our Constitution, other legal documents of the founding era, particularly individual rights provisions of state constitutions, commonly included a prefatory statement of purpose. See generally Volokh, the Commonplace Second Amendment. Okay, this is actually a recommended reading in the Federal Society's Bibliography of Conservative and Libertarian Legal Scholarship. If you flip to the Second Amendment, this is one of the first articles they recommend that you read. And Eugene Volokh has been a very active participant. So you see that by mobilizing a UCLA legal scholar and the scholarship, Scalia's suggestion that they read the Second Amendment backwards seems a little less loony, okay? Gives it a little bit more legitimacy. Let me give you another example. Another key to sort of radically revising our interpretation of the Second Amendment was to persuade us that the language free state, state capitalized there, did not refer to state, Massachusetts, Colorado, California, Virginia, as it does in every other place in the Constitution, right? That it meant something different, right? So how does he persuade us of this? Well, again, he mobilizes another law review article by Eugene Volokh. And he writes, the phrase security of a free state meant security of a free policy, not the security of each of the several states as the dissent below argued. This was Justice Stevens writing in dissent. It is true that the term state elsewhere in the Constitution refers to individual states, but the phrase security of a free state and close variations seem to have been terms of art in 18th century political discourses, meaning a free country or free polity. See Volokh, Necessary to the Security of a Free State, right? Notre Dame Law Review. Scalia made it easy for me because he actually cited his sources. Unlike Justice Thomas, who has been known to crib wholesale parts of law review articles and plant them in his concurring opinions. And that was actually pretty fun to discover as well. But Scalia makes it easy because he actually cites the law review article that this comes from. Okay. In the course of his opinion, Scalia cites several other law review articles from Federalist Society Network members. Another one by Eugene Volokh to complete the trifecta, an additional law review article by Randy Barnett, so you have the solid line coming from the Academy. He also mobilizes dozens of sources of originalist or historical evidence mined from Federalist Society amicus and litigant briefs, so you have here the solid lines transmitting the intellectual capital from these two boxes too. Putting all this evidence together, right, we can start to see how a self-described society of ideas like the Federalist Society actually becomes quite important in helping Supreme Court justices justify radical departures from precedent and constitutional doctrine. To return to co-founder David McIntosh's quote, we can start to see some of these untold ways, right, that Federalist Society members are influencing the policymaking process. So while the focus of Ideas with Consequences was on tracing the kind of influence I illustrated with the Heller example, in the book's final chapter, I identify 3 additional ways in which the Federalist Society Network has helped create the conditions for a constitutional revolution. So this point here, right, most of the book examines how once Supreme Court justices were ready, right, to move the law in a radically different direction, then the Federalist Society became a series of active conduits, right? Once they flipped the switch, the conduits lit up, right, and they supplied the intellectual capital. But I argue there are also ways in which they helped the justices themselves get to the position where they were ready to move the law. And that's what I discuss in the book's final chapter. So there are 3 ways. First off, if you want a constitutional revolution, you have to have the right cast of characters on the bench. You have to have a majority of justices, and as William Brennan would say, all you need to know is this, 5. With 5 votes, you can do anything. You have to have a majority of justices on the bench first, right? It's a necessary condition, but not a sufficient one. How's the Federalist Society affected that? Well, they have become the de facto credentialing institution for any judge hoping to get nominated under a Republican administration. Not only that, they have filled the Office of Legal Counsel and started to control the nomination process itself. So in my other work, I've examined the role in which the Federalist Society Network sort of infiltrated the Justice Department and really served as the gatekeepers for judicial nominations under the George W. Bush administration. This was on sharp display when President George W. Bush tried to nominate Harriet Miers to Sandra Day O'Connor's vacancy on the Supreme Court. Miers was a virtual unknown to the Federalist Society, a close personal friend of the Bushes. And after a loud and vocal revolt from the Federalist Society Network, Bush withdrew her nomination and appointed Federalist Society stalwart Samuel Alito. Now, one of my interviewees said, you can't have a conversation in Washington about judges without the Federalist Society being part of it. No Fed Society credentials, that's going to hurt you. It hurt Harriet a lot. We need to know you. You need to be at dinners, you need to be gripping and grinning, right? It's just as simple as that. So, Not only have they become the de facto gatekeepers for judicial nominations, they've also helped produce a farm team, right, of bona fide conservative judges and justices who are unafraid to show their ideological stripes, okay, which helps Republican administrations make sure that they get the right kind of judges and justices on the bench. Second, once you have the right kind of judges and justices, the Federalist Society acts as a vocal judicial audience, and I love this concept. It was from a book by Larry Baum called Judges and Their Audience, right? So the Federalist Society acts as a vocal judicial audience to keep those judges and justices in line. How do they do that? Well, very directly, right? There's direct feedback mechanisms between some of these Federalist Society network members and these judges and justices. Many of them clerked for them. They see them at meetings. They see them at conferences. So chapter 6 of the book is just chock full of interview data, where I have various members of the Federalist Society network saying, you know, when Scalia wrote that opinion in Gonzales v. Raich, his trading stock really went down in the Federalist Society market, and Clarence Thomas's trading stock really went up. And I appreciated having the chance to tell him that I disagreed with him. You know, where? At Ted Ellison's barbecue, or at, you know, this Federalist Society network meeting. There is a direct feedback loop. This is important because historically, the theory went conservative judges were subject to what is now popularly referred to as the greenhouse effect. Doesn't have to do with greenhouse gases. The greenhouse effect refers to Supreme Court reporter Linda Greenhouse for the New York Times. And the idea was you got these good conservatives on the bench, but then they moved to Washington, and they really cared what Linda Greenhouse thought of them. And they really cared what the Georgetown set thought of them. And so they started drifting to the ideological center. And worst of all, they started drifting over to the left. Right? Having an alternative vocal judicial audience like the Federalist Society helps mitigate that. Right? So they're not just responsive to the Washington liberal elite. They're responsive to the Federalist Society network. There's a second way in which having a vocal judicial audience helps. And this has to do with the phenomenon of signaling. There's a great sort of burgeoning literature in political science on judicial signaling and the effect that has on agenda setting. Why is signaling important? Well, as we know, unlike congressmen, the Supreme Court can't set its own agenda. It's not self-starting, right? It can't make cases appear before it as if by magic. What it can do is signal. It can signal the kinds of cases it wants to get. How does it do that? Well, through concurring opinions, through dissenting opinions, through public appearances, talks, interviews, all right? And this has been shown to actually influence the kinds of cases the Supreme Court gets. If you have a sort of mobilized network of foot soldiers who are listening to those signals and can effectively respond to them fast and find, finance, and orchestrate the kind of litigation and questions the court wants to hear, it sort of it shortens that response time so that the justices who are really willing and ready to move the law can get the cases they need to move the law. Okay, so that's the second way in which having a vocal judicial audience helps. Finally, the Federalist Society has done more than any other organization to legitimate the theory of originalism. Okay, that the Constitution should be interpreted according to its 18th century original meaning. In the 1970s and 1980s, and anyone will tell you this, just listen to Robert Bork's confirmation hearings Larry and I were just talking about. This was considered out of the mainstream, ludicrous, off the wall, okay? No one took it seriously. Now, thanks to the hard work of the Federalist Society, through its events, through networking like-minded academics who have been publishing on it, through speaker series and debates and books, there are dozens of ways in which they've nurtured this theory and helped support it, right? And now, originalism is not only considered a legitimate method of constitutional interpretation, it's become the dominant one, at least on the Supreme Court. Even liberals take it seriously, right? Liberals in dissent respond in the discourse of originalism to their conservative counterparts. That's how you know the debate has changed. By working to legitimate the theory, the Federalist Society has made the decisions of conservative Supreme Court justices seem more plausible and more legitimate. Okay, wrapping up. So Ideas with Consequences examines what the Federalist Society for Law and Public Policy Studies does. All right? It provides a framework that we as students and observers of American politics can use to make sense of its influence, and it provides evidence of that influence in concrete cases. Those are the two primary contributions of the book. But the book doesn't conclusively answer the question of what the Federalist Society is. Is it, as several members suggested to me in interviews, sui generis? Or is the Federal Society, as Larry Baum has written, simply a more formalized or stylized version of the kind of informal elite networks that have always operated within the legal community? As evidence, Baum points to the Franklin Roosevelt era justices, who, as other scholars have documented, maintained strong links with liberals in the academy, in the executive branch, and with judges on the courts. There's a great little story about Felix Frankfurter and his little hot dogs. He had this pipeline of clerks running from Harvard Law School, right? There was a salon where they gathered. As my interviews revealed, the founders of the Federal Society were conscious of the Roosevelt-era model, and they sought to build a counter-network that would rival what the left had built from the 1930s onward. Moreover, this period in time witnessed several seismic shifts in constitutional jurisprudence. You have the demise of Lochner-era jurisprudence, the rise of a sociological jurisprudence that justify an expanding role of government in the economy, and of course the Warren Court's rights revolution. If we follow the logic I outlined earlier about reconstructing constitutional frameworks in doctrinal distance, these eras would seem ripe for a Penn analysis, right? To figure out who, if any, were the networks of elites who were diffusing and supplying intellectual capital, helping those judges and justices revolutionize jurisprudence during those times. Who were they? An analysis like this might reveal that the Federal Society is just a more formalized version of something that's always existed within the legal community. Alternatively, it might reveal something else. Perhaps the Federal Society's innovation, right, the act of formalizing and institutionalizing these once informal networks, itself represents something of a critical juncture within the legal community. That is, the Federal Society model, though inspired by the liberal legal network, is now viewed as strategically superior to its prototype. The informal networks and processes that successfully helped support and implement the rights revolution on the left are now seen as an insufficient counterweight to the more formalized and organized Federal Society network. The best evidence of this, some of you might already know, was the founding in 2001 of a progressive counterpart to the Federal Society called the American Constitution Society. The ACS is the mirror image of the Federal Society in its institutional machinery, with an emphasis on creating a community of legal elites who share a particular legal and constitutional philosophy, networking these elites and supporting their professional development. Like its philosophical foil, ACS boasts a growing number of lawyer and student chapters. It sponsors conferences, debate, colloquia, networking events. As founding executive director of ACS, Lisa Brown, explained to me in an interview in 2008, quote, "The ultimate goal of ACS is to further a progressive vision of law and policy, to get ideas out there and have them be acted on and implemented. Over time, as people go into different positions of all sorts and different jobs in government and judging, then you actually see more of the realizing of the ideas." Sounds a whole lot like co-founder David McIntosh explaining the Federal Society model. Brown continued on saying that the ideas were important, but it was the ideas connected to the people, the network, that had been the Federal Society's formula for success, a formula that the ACS has been doing its best to try to imitate. And while I can't pretend to have captured the Federal Society's precise formula in these pages for success, future scholarship might use the dimensions of Federal Society influence that I've outlined in the book as a starting point for evaluating how far the ACS is, at just over 10 years of age, from having the kind of influence that its founders hoped it would. Finally, in addition to these empirical questions that I think warrant further investigation, there are also normative questions that merit some consideration. If the Federal Society model and the rise of its rival, the American Constitution Society, does represent a critical juncture within the legal profession, that is, a new model of identifying, training, promoting, and disciplining lawyers on both the right and the left, from professional cradle, law school, to professional grave, retirement, then what consequences might this have for the legal profession specifically and for the politicization of law more generally? By governing the ideological socialization of young law professionals and plugging them into a political network that creates incentives for students and lawyers aspiring to top clerkships, positions in the national bureaucracy, and federal judgeships, some fear that these legal hybrid organizations have further blurred the crucial divide, however tenuous, between law and politics, and have contributed negatively to the polarization of the law. Others, such as George Washington University law professor Oren Kerr, say this is an improvement on the old model, right? In the old model of networking, It was based on family ties, school credentials, right? Backdoor. You couldn't see it. And as he writes, now the networking is more open. These normative concerns will be important for scholars, students, and practitioners of American politics and law to think about and engage with as we seek to understand and evaluate the mechanisms, old and new, by which ideas can and do have consequences. Thank you, and I look forward to your comments and questions. You're welcome.
Okay, with that, I'd like to bring up Fred Smith, who is our respondent.
Thank you very much, and thank you, Amanda. This was a pleasure to read. It's a remarkable achievement on a number of levels. First, in thinking at a broad level about the ways in which various networks can translate their ideas into power. It's also a remarkable achievement in thinking about the relationship between political power and judicial power. So we as lawyers like to think of those as different things, and certainly in confirmation hearings, right? The Chief Justice famously said that this is just about balls and strikes, but there's a way in which we all know better, and you sort of very early in the book make clear that you don't take that seriously, and that's exactly right, I think, for the reasons that you've demonstrated. And it also tells us about an organization that has had a profound influence on the law and therefore on the nation. Right? Once you say that something is unconstitutional, you have, by definition, taken it off of the table for political debate and political discussion. In commenting today, I want to divide my comments into three sections. The first one is about ideas. The second one is about the word with, and the third one is the word consequences. So I'll begin with the word ideas. So first, what I want to kind of ask you about is situations in which there are ideas that may be in tension with one another among folks who are sympathetic to the Federalist Society's principles and how those get mediated. And so I'll give two examples. One is the notion of what I'll call active judicial engagement, but what you call on page 61 judicial activism, versus the idea of interpreting the law. That is that, so one of the principles seems to be active judicial engagement, but another seems to be it's about interpreting the law, it's not about making the law, right? And that both of these are sort of central to the Federalist Society mission. Another example would be the idea of state sovereignty and the idea of limited government. And so I'll take both of these in turn. So first, with respect to judicial activism or active judicial engagement versus interpreting the law. So the Federalist Society encourages active judicial engagement on questions like separation of powers. And this is true even when it means striking down important legislation passed by Congress, right? So you give the example of D.C. versus Heller, striking down the handgun legislation in Washington, D.C., but of course there's Citizens United, which you talk about a great deal in the book as well, and which folks I'm sure in the audience are familiar with, where in a way that was counter to what the vast majority of the American people said they thought the law should be, and in a way that required overturning past precedents, in a way that required asking the litigants to file briefs that they hadn't previously filed because they wanted to go further than the litigants wanted them to go. And you, as you identify in the book, they did all of these things in order to strike down legislation that was passed by Congress. Another stark recent example, Shelby County versus Holder, where the United States Supreme Court struck down the coverage formula of Section 4 of the Voting Rights Act. And I'll just say as an aside, when recently watching Selma, I almost wished at the end when they were saying where these things are today, that they said And Section 5 of the Voting Rights Act, which these individuals worked so hard for, was recently gutted by the United States Supreme Court. Or, some of the other examples in Morrison, where the court strikes down important provisions in the Violence Against Women's Act. Prince, where the court strikes down and validates important provisions from the Brady Act. And one, of course, could go on and on, right? So that's kind of this active judicial engagement model, but you also have this model of interpreting the law and not making the law, right? So as you note in the book, the court, or Federalist Society members are very skeptical of this notion of substantive due process, and therefore very maybe not just therefore, but because as a result of, it's hard to know, skeptical about Roe versus Wade and the idea that the Constitution protects reproductive autonomy for women. So how do they mediate these various principles? So you point out that you called the kind of the more judicial minimalism model the Wilkinson model after J. Harvey Wilkinson, right? We could also maybe call it the Posner model after conservative judge and legal scholar Judge Richard Posner. So one possibility might be that when we have these disputes, that originalism might be kind of the lodestar. But that doesn't seem to necessarily entirely tell us the full answer. And this is especially true in situations where the United States Supreme Court overturns legislation without relying on originalism. So for example, Shelby County versus Holder, where they strike down Section 4 in the coverage formula of the Voting Rights Act, has nothing to do with originalism. No one asks, what would the folks who created the Equal Protection Clause and created the 14th Amendment, what would they have thought about the Voting Rights Act? That seems to be wholly irrelevant. Or in Parents Involved, where the question is whether or not local school boards can voluntarily integrate. That is, can they consider race in order to integrate schools rather than segregate schools? And where the court 5-4 said that they couldn't consider race to integrate schools, just like they couldn't consider race to segregate schools, and in fact cites to Brown versus Board of Education and attempts to actually draw on that legacy. That's the closest they come to originalism, is citing the oral argument in Brown versus Board of Education. But there's no discussion about what would Charles Sumner have thought, what would Frederick Douglass have thought, et cetera, et cetera. Next, on the question of this federalism or state sovereignty, we might call it, and limited local government. So when you talked about state sovereignty, you talked about a couple of things, but one of the focuses was what we call anti-commandeering legislation. That is, Congress is not permitted to coerce local governments and state governments into federal service. But there's another strand of state sovereignty jurisprudence, state sovereign immunity. So the idea that because the state is sovereign, that we the people cannot sue the state. So some people connect this to the ancient idea that the king can do no wrong. And so this idea of state sovereignty and the idea of limited government seem to be kind of in tension with one another. There also are related doctrines like qualified immunity that make it difficult to sue government officials for money damages. Also doctrines like the doctrine that you can't sue a local government for a constitutional violation under a theory that simply that one of their employees violated the Constitution. You have to actually show a policy. And in fact, there have been instances in which groups like the Cato Institute have actually filed briefs in favor of wider ability to be able to sue under these circumstances. And I've served on panels with folks like Ilya Shapiro, who is a member of the Federalist Society, who seems open to this. So I'm curious, when you have these sorts of tensions, what do we do with them? That said, on that latter one, I'll acknowledge that I write about state sovereignty and I write about state sovereign immunity. And of course, people often say when you have a hammer as an academic, you see a nail everywhere. So sorry that I saw a nail. So that's the ideas point. Next, on the with point. So your exploration of the ways that ideas translate into judicial opinions is filled with illuminating insights. Not only do you demonstrate the ways that judges, professors, amici, and to a lesser extent clerks have influence, you also show that sustained engagement is important in order to prevent the greenhouse effect. So it's important to train and socialize and educate. I guess one question I do have is, how do we really know that this is a result, though, of the Federalist Society? That is, how do we not, why isn't this just, and you kind of allude to this at the end, but why isn't this just a counter-revolution that always happens in the law over and over again, right? So in the early 1900s, we had the Lochner era, which resulted in the invalidation of various child labor laws, et cetera, and then started striking down New Deal legislation to a point where the continuum that would not stand. And as a result, in part because of FDR and what we call the switch in time to save the nine, when he said that he was going to just change the number of people on the Supreme Court and add more people to the Supreme Court. And the Supreme Court quickly changed its tune, and we kind of have an era then of judicial minimalism with people like Judge Frankfurter. And then it's, a response to that kind of comes later. It says, wait, this is insufficiently protective of individual rights. And so we have the Warren era, right? And then there's a response to that, wait, we are handicapping police too much, et cetera. And then we have the Berger era, right? And so isn't this just sort of a natural thing that sort of that happens in the law where individuals who feel under siege are going to respond, and that even if the Federalist Society had never been invented, that we would see these conservative individuals who felt under siege this way have a profound influence on the law once folks like President Reagan and President George W. Bush served in the presidency. And so kind of to that end, if you can sort of maybe think or compare your work a little to someone you cite a lot in the book, Tellis, in his book, The Rise of the Conservative Legal Movement, but his isn't just about the Federalist Society, right? It's about the Center for Individual Rights and the Olin Foundation and the Institute for Justice, et cetera. So when you have a group that has 40,000 members, right, how do we really know that it's them? Inevitably, if they're conservative, they're going to be a member. But maybe that tells us something in and of itself. And I'll concede that I am a member of the ACS, a card-carrying member. So there's that. Finally, with respect to consequences, so your project explores ways in which the Federalist Society has made a mark and made various changes in the law. I guess one question that I have is, what can your model teach us about maybe the direction that the law is going next, right? Can we predict, based on the network, based on what folks in the network are writing, based on what signals there might be right now in judicial opinions, right? Because it's not a history book, right? Like it's a political science book about an organization that is very much active and perhaps even growing in its influence. So what can that teach us about what's next? Right? What's the next Citizens United or Shelby County? God help us. So, thank you very much.
What we do now is have a response, and then
I'll be
we'll
brief.
open the floor up to questions from the community.
Yeah, I'm going to be brief because Fred and I will have time to talk about this afterwards, and I want to hear questions from the rest of the room. Your first point about ideas being in tension with one another, I think that's an important one. In the dissertation, I actually explored a wider variety of cases. I looked at state sovereign immunity as well. And I found that there were certain cases that would be predicted by scholars who study the conservative coalition, right? That predictably will divide the Federal Society just like they would divide the conservative coalition, right? The Federal Society is not unique in that regards. And I think maybe this is why it's important in the Penn model that I lay out to talk about beliefs as I talk about them as instrumental, right? Not sincere and objective. Scalia is all about states' rights until it has to do with the Controlled Substance Act, right? And then he votes with the federal government. You pointed out a number of other examples. I can't pretend to apologize. They are aware of these tensions, but the project of the Federal Society, so the president of the Federal Society is Eugene Meyer. His father was Frank Meyer, who's often credited as like the father of fusionism, right? Libertarian means to conservative ends. How do you bring these different strands together? There's a conscious effort within the Federal Society to try to fuse as many of these various coalitions as possible. So yes, I'm sort of biased in my case selection because I'm selecting cases that do deal with state sovereignty, but they deal with issues of state sovereignty upon which there is really no disagreement. So I am selecting the cases arguably where the epistemic community is, or the political epistemic network is going to be most cohesive and therefore maybe most powerful, right? And there are these cases that routinely divide the conservative coalition. City of Bernie v. Flores was one that I looked at originally in my dissertation, and then I realized that this dealt with the Religious Freedom Restoration Act, which was a federal piece of legislation that said every level of government out down to the city council must apply strict scrutiny when it comes to religion cases. So this was appealed up to the Supreme Court, and the Supreme Court said, this is outside of your power, federal government. You cannot dictate that every level of government down to a city council has to apply strict scrutiny in every religion case. What you can do is hold yourselves to that standard. So they upheld the part where the federal government can hold itself to strict scrutiny, but they struck down everything else. You have religious liberty advocates, libertarian types, who were arguing we wanted more religious liberty because the current doctrine was suffocating religious liberty. They're actually arguing in favor of federal power. And then your traditional kind of states' rights folks who don't care much about religious liberty who are arguing against it. So you have these cases that routinely, and I don't pretend to try to make sense of them. I just do my best to kind of document the ideas and see how they work. Secondly, how do we know that this is an account of the Federal Society? Is it just a counter-revolution? I would say this. We have a saying in political science, the Supreme Court follows the election returns, right? You get enough conservative presidents, they're going to appoint enough judges and justices, you're going to see a constitutional revolution. Almost, I would say, because you have to get the right kinds of judges and justices. And really, if you look at the Nixon appointees, they were all over the map. Right? He had no idea what he was looking for. I'm just going to try to get some conservatives. I'm going to try to do this. And it ended up not working out very well for Nixon. Right? So if we didn't have the Federal Society, sort of an organized coalition, sort of socializing and training, creating this farm team of sort of verifiable conservatives that Republican administrations could really depend on. You may have a counter-revolution, but it may not be the same scope and magnitude as we're seeing it now. And of course, we don't have a counterfactual. So, but that's what I would argue, that Federal Society has given Republican administrations a barometer, right? They know what they're looking for now. Nixon had no idea what he was looking for, right? I'm looking for conservatives. I don't know where to find them, but I'm going to get a couple on the court. And it didn't work out. What does the model tell us about where the law is going next? That's a great question. I don't draw any relationships in the book between frequency of discussion of an issue and whether or not that issue ends up in front of the Supreme Court. I think there's probably some kind of relationship between signaling and the mobilization that the Federal Society has helped enable of conservative litigants, public interest law firms. They're in conversation with academics who help them develop the strategies. And Tellis does go into detail about this. He kind of connects all these different factions of the conservative legal movement and talks about how they're helping one another sort of usher in this conservative counter-revolution. I think he does a great job of that. To clarify, I am not saying the Federal Society is solely responsible for the conservative counter-revolution. What I am saying is that the Federal Society has helped shape the content and direction of that revolution, right? So I'm not making these like strict causal claims that the Federal Society is responsible for it all. The Federal Society is one component. And the contribution of the book, I know everyone kind of thought the Federal Society was a component. Tellis writes about it, and Southworth writes about it in her work, but they didn't show how it worked in concrete cases, right? So I think that's the real contribution of the book, and then also sort of thinking theoretically about this is not just about the Federal Society, right? Where do we go next? Can we kind of think about the critical juncture that the Federal Society has maybe created in the legal profession? So those are my brief responses, because I'd love to hear what everyone else has to say too.
Okay, so let's open up the floor, please.
You mentioned the Federalist Papers. There's the Federalist number 10 by James Madison. He warns about the danger of fiction trying to conquer the American government, dominate or influence the American government. So there is much talk about conservative ascendancy, you talk about conservative counter-revolution. Would you say that the polarization of American politics and now the dominance of the Republican Party in Congress as well, would you say that this is a faction trying to conquer the agenda?
Yeah, so I mean, when I teach Federalist 10 in my Intro American Politics class, I subtitle it Everything You Ever Wanted to Know About Factions and More, right? Because Madison's talking factions, factions, factions. And I think the important point that Madison's making in Federalist 10 is that you can't eliminate factions. So how do you control them? You have a lot of them, right? You have a lot of little factions competing, and you make sure they're fluid, so that you may be my friend today, but you're my enemy tomorrow. So the factions don't harden against one another and become permanent. And this is what happened in the Civil War. One issue so dominated that you had two factions and nothing else mattered. So I think Madison's point is that as long as we have lots of little fluid factions, we're okay, because let ambition counter ambition, right? The factions will counter one another. I think one of the troubling things about the rise of the Federal Society and the American Constitution Society is this looks a whole lot like two political parties in the law, right? And so the upside of that is that voters, when they elect a president, will know what they're going to get. If they elect a Republican, they're going to get more John Roberts and more Samuel Alito's and more Scalia's. If they elect a Democrat, they're going to get maybe more Sonia Sotomayor's, right? So it makes it clear choices for voters, but it eliminates moderates, right? I don't know that if we continue along this path, and if ACS does become the Federal Society on the left, I don't know that we'll ever get another moderate. Maybe that doesn't matter, but Madison would think it would matter. So I think that's where factions play in.
Well, I'll ask the question.
Okay.
As somebody who pays a great deal of attention to the American right, I am struck by the presence not only of the Federalist Society, but of a Christian, an emerging Christian legal establishment. It became sort of well known in the Bush era when someone called Monica Goodling was discovered being deeply involved in scandalous behavior with respect to local attorneys general. And it turns out that Monica Goodling was one of something of over 100 members of the Bush Justice Department who were products of an alternative legal establishment which identified itself as teaching Christian law. It's quite conservative, and its impact, to wit, 100 members of the Bush Justice Department, was quite powerful in the years 2000 to 2010. So my question is, what is the relationship between the two? Do these guys know each other? Is their project the same? And what kinds of coordination might exist between them?
So Larry did not mean to set me up perfectly to talk about my next book project, but he actually just did. Josh Wilson, who's at the University of Denver, and I are actually co-authoring a book project examining the rise of evangelical Christian law schools and legal training programs. So when you think about the Federal Society Network, they tend to be conservative and libertarian dominated. Many of my interviewees talked about how the sort of moral conservatives or the evangelical conservatives were not brought into the table. They were not brought to the table when they formed the Federal Society. Why? Folks like Steve Calabrese and the founders of the Federal Society wanted to be taken seriously by liberals, right? And they thought that their best chance to be taken seriously by liberals was to sort of aim at the more libertarian arguments. So when the Federal Society was formed, it has taken on a very, very libertarian bent, particularly when it comes to sort of the key actors, those who are invited to present at national conferences, who are sort of the founding generation. That being said, we do start to see some kind of movement of these two factions to work with one another. The Federalist Society, when it decided that it was going to sort of mobilize, decided to infiltrate existing institutions, right? It formed the Federalist Society within law schools that were already credentialed, that were reputable, elite law schools. And they infiltrated that and they created a home for conservatives and libertarians. Evangelical Christian leaders, Pat Robertson, Jerry Falwell, Tom Monaghan, felt that they couldn't actually infiltrate those institutions, that they were too hostile to evangelical Christian beliefs. So they founded their own law schools. Regent was the one he was referring to. Liberty Law School and Ave Maria are the three principal ones. I'll be doing interviews at each of them in April. So one of the interesting questions to examine is, what happens when a movement, instead of infiltrating existing institutions, decides to form parallel institutions, right? What does that mean for creating future foot soldiers for the movement, right? If we think about political epistemic networks, what do the pathways look like when you come out of a Regent or of an Ave Maria versus you are a conservative who went to Harvard or Yale or Princeton? So it seems to be that I would say one more thing on the topic, because it's in very early stages. But I would say that I think the Affordable Care Act is actually bringing together these disparate factions of the conservative legal movement. You see them cooperating on Hobby Lobby. You see them cooperating on a variety of different issues. And you have folks from the ACLJ, Jay Sekulow, from ADF, Alliance Defending Freedom, from the Beckett Fund for Religious Liberty, appearing now at Federalist Society events in a way that they never did. Because the Federalist Society, they're united in their opposition to Obamacare, and this may be an issue that kind of brings the disparate factions together. So,
Thank you. Okay, over there, please.
Yeah, I want to get a bit specific, and I wonder if you know what the presence of Federalist Society is in the Berkeley Law School. The reason I'm asking this is that I'm somewhat mystified, not only at the presence of Professor John Yoo in the law school, but also at the fact that the faculty is making no move to investigate a professor who has brought such a program to the law school here.
So if you read the back of my book, John Yoo has blurbed it. It was a very controversial move. I interviewed John Yoo. He was one of my first interviews. He was here. He had grown up with the Federalist Society. He's very insightful about the organization. Very good interview. And he clearly has a lot of credential within the Federalist Society network. I don't know what the student chapter here is like. I think I was telling Larry earlier, each of these student chapters kind of take on their own cultural identity. And what I'm really looking at are sort of the national actors, the big players, the ones who are invited to speak at these national conferences. So I think, I'm not trying to import their beliefs to all 40,000 members. So in essence, I'm really looking at 1,190 of them, right? And these are the sort of center of the network, and these form my core analysis. John Yoo is in there. John Yoo is here, right, within there. I don't know the relationship between here and what's going on at the Berkeley student chapter. I just don't know anyone who's a member, but they have an increasing presence at all of the elite law schools. I mean, they're taken very seriously. They're well-funded. They put on excellent events. They're a growing presence and a presence to be reckoned with in any law school now.
What about on the faculty?
I don't know anyone. Fred would probably be better equipped to answer this question. Who else on the faculty? Is it card? Are you now, or have you ever been a member of the Federalist Society? I don't know. Yeah.
Please.
Yes, thank you very much. I'm sure political science has had droves and droves of things to say about elites and what they are, what they do, and you use the term quite prolifically. But I'm wondering whether, you could argue, it might be said that some elites are more elite than other elites, and that has something to do with their access to money, to monetary elites, which you did really say are part of the Federalist juggernaut. It seems like you describe it as a kind of intellectual and social juggernaut. The money doesn't seem to play a role in your account, and therefore are they no more elite than other elites? Thank you.
Yeah, so they don't, they are financed by all the familiar cast of characters on the right, by the Koch brothers, by the Olin Foundation, but all of their money goes into their programming and to support their programming. Like, they don't give money to candidates so in that way, you know, you have to think of them a little bit differently when it comes to the financing, because they're not donating to political campaigns, they're not forming political action committees in that same way. At the same time, they are, as I talk about in Chapter 3, they have laid the intellectual groundwork for the Citizens United decision, right? They are, you know, about 6 or 7 individuals working with the Federal Society's Free Speech and Election Law Practice Group single-handedly came up with a litigation strategy that allowed the Supreme Court to make its ruling in Citizens United, and then McCutcheon. You asked me to fast forward. What I'm seeing a lot from the Federal Society Network now is a movement to strike down disclosure laws. That's the next one. The Supreme Court has upheld them thus far, but you can see that there is sort of a movement afoot to try to build, right, to strike down disclosure, which would further weaken campaign finance. So I don't know if that directly answers your question, but
Well, my question was kind of vague anyway. I'm not.
I made with it what I wanted to make with it, apparently.
Spiritists, so, you know, terrible.
Hi, this may be a two-part question,
Sure.
depending on your answer to the first part.
Okay.
So the first part of the question is, through your research, were you able to get a read on how many women and people of color are in the Federalist Society?
I don't have exact numbers, but I did a lot of participant observation. I spent some time in DC. I went to, Scalia gave a talk on his book. I went to conventions. I went to meetings. It is largely white male dominated. I think there's an increasing number of women who are coming out as vocal conservatives and have become kind of tokens. And I interviewed Gail Harriet at USD, who was instrumental in the repealing the affirmative action or passing the anti-affirmative action proposition in California. Lillian Bevere, who was very active, she's at UVA in campaign finance stuff. There's a woman, Carrie Severino, who we brought out to Pomona College, who was defending the, in McCullen v. Coakley, in the abortion buffer zone case in Massachusetts. She was the only, my students found her because they wanted a woman to come and defend the abortion clinic protesters. And so she actually clerked for Thomas. And so we had a nice long conversation about what that was like. And I think there's an increasing number of women, but honestly, I mean, it is still white male.
Well, and you mentioned tokenism, so in your interviews, did a lot of the white men that you spoke to, in the same way that a lot of Republican Party leaders do, at least pay lip service to the fact that they want to bring more people into the tent?
No, they don't talk that way, right? They wouldn't talk that way. It wouldn't be about sort of diversity for the sake of, you know, the Rainbow Coalition. They talk about their beliefs and their principles a lot.
Right.
And in fact, I didn't interview them about anything that had to do with race, sexual orientation, marriage equality, gender. I was interviewing them about things like federalism, states' rights, where they stand on campaign finance. So these were conversations that were easier to have than would be these other conversations. So yeah, I've never heard anyone, in fact, the women in the Federal Society will reject anything that appears to help women because, you know, they would feel like that's paternalistic. The government has no role in that, right?
How can Federalist Society reconcile its supposed belief in libertarianism with positions it takes on things like abortion rights, drug laws, involuntary incarceration in Guantanamo Bay? I mean, and even the whole Citizens United decision, which essentially dilutes individual speech and the power of individual speech in government to surrender it to a corporate power, which I know is an entirely separate issue, but all these things seem to be counter-libertarian.
So there is no tension within the Federal Society Network about the Citizens United decision. More speech is better. And we shouldn't discriminate on the part of corporations just because they happen to be different speakers, right? So this is a we believe that more speech is better, and anything that tries to equalize speech resources or discriminate against certain forms, corporate or union, is bad, and the government should not be meddling in that. On the other issues, I think I mentioned this earlier, these are issues that divide. the conservative legal movement. Like John Yoo would be someone who supports abortion rights. Richard Epstein would be someone who is against NSA surveillance. John Yoo would be someone who was for NSA surveillance, right? And there was a very memorable Federalist Society panel on the war on terror where they just went after each other on this. And there's some interesting ways in which the Federalist Society's belief, sort of this fusionist idea, again, if we have a strong national defense, this will lead us to libertarian ends. Then other libertarians say, that's just inconsistent with libertarianism, right? You can't say big government here but nowhere else. So there is that tension, and I don't examine those issues in the book, but it's there, and it's pretty prominent. Marriage equality is probably another one, although they don't talk about it a lot in the Federalist Society. But you have Ted Olson, who was one of the patron saints of the Federalist Society, maybe still is. His barbecue was the place to be, I was told by many Federalist Society members. I don't know if people still go to his barbecue now that he's sort of taken up the Prop 8 mantle. I haven't re-interviewed them yet, about that. So they exist.
Thanks. I thought this was really interesting. I'm looking forward to looking more at the case studies because I know the inside of some of these like amicus brief roundups on issues and all of that. And they're done by different parties that organize business interests and sometimes on the left as well, especially like gay rights issues. I've seen that. But I wanted to talk about this issue about the American Constitution Society for a minute because I think that people are thinking about ACS as a counter to the Federalist Society or the organized legal right. And something that strikes me as a difference, having been involved in the American Constitution Society when I was in law school 5 years ago or so, was that it seems that the Federalist Society and organized right are playing this kind of, what we were talking about earlier, the right flank strategy, where, and the issue we're talking about Roy Moore in Alabama. So Roy Moore would not be the keynote speaker at the Federalist Society convention. However, the Federalist Society and right legal institutions, I think, are taking the view, like, let's let 1,000 different strategies develop and then try to figure out how to work with them and how to create space for them and how to play this right flank strategy. Now with the ACS, it strikes me as very much a part of the institutionalized liberal left in America. And so actually maybe this is a legacy of the Cold War, or maybe it's about the fact that liberal elites in the US also have tight networks with organized business interests. But the left flank strategy doesn't seem to be as operative, especially on economic issues.
Yeah.
And I think that that's actually a dynamism that the right is able to draw on, that the left is not. And I think that in terms of looking at the ACS, I think that's an important place to look.
Yeah, and that's so I just start to talk about the ACS. I interviewed its founding executive director, interviewed Goodwin Liu before he was appointed, and actually talk about the failed nomination of Goodwin Liu to the Ninth Circuit as evidence that maybe they're not the Federal Society of the left because Obama didn't fight for him. And Sonia Sotomayor, who is by all accounts now kind of the up-and-coming ideal progressive judge, was an unknown to the ACS. In fact, some people expressed disappointment in her appointment because she was an H.W. Bush nominee. And Elena Kagan was involved with the ACS, but she also spoke at a lot of Federal Society meetings. So when you look at the DNA of Obama's nominees, it's not clear that you're finding the ACS gene in the same way that if you examine the DNA of the George W. Bush nominees, you will consistently over and over and over and over and over find the Federal Society gene. And one thing about the American Constitution Society is that it is one of many institutions on the left. Right? And that's how my interviewees described it to me. If you want to become a judge in a Democratic administration, do you get deeply involved in the ACS, or do you get involved in the American Bar Foundation, or do you get involved in the ACLU, or do you get involved in any number of other credentialing institutions? So there are far more options on the left, and you're right, they're more establishment.
Because it's not the National Lawyers Guild.
It's not the National Lawyers Guild, that's right.
So is this a response to trying to get confirmation that if the profile is bleary, the chances of getting nominated are maybe better, knowing that Congress is constituted the way it is now?
Yeah, I mean, I think Goodwin Liu may have been like the Robert Bork of his generation. He wrote a ton on his theory of constitutional interpretation. He was deeply involved with the ACS, and he got, and I excerpt sort of the transcript from his confirmation hearing, and there's just a particularly telling instance where John Kyle of Arizona is going after him for being involved with the ACS. Well, you're saying you're going to read your values into the Constitution. You're saying that this is judicial, and he's like, no, I'm saying that I think that there are majestic generalities, and he's trying to backpedal from it. One of the things about the Federal Society that has been interesting is, John Roberts and Samuel Alito, very little paper trail, right? But yet everyone within the Federal Society network knew they were bona fides. And everyone in the Republican administration that was populated by Federal Society network members in the Justice Department knew they were bona fides. So this is really what the left is up against, right? Can you not leave a paper trail? Sotomayor was almost perfect, right? She didn't have a big paper trail. People were actually kind of disappointed. No one really knew she was, and now she has turned out to be the ideal progressive judge.
Still.
Still, yeah.
Still.
Yeah.
Yes, so as I understand it, the society seems to be a network of intellectuals.
Mm-hmm.
But, if we were to simplify this, how does this differ from any political lobby or pressure group? Oh, by the way, let me just interject. The Citizens United, I'm not sure how that can be equated with more speech when it seems to squeeze out more speech. I meant to say that first. So
I'm not here to defend this view. I'm just here to report on it.
I know you're not, but just following that argument.
Sure. It's on the record.
Yeah, just following that argument. Although it may be argued that way, I'm just offering that it doesn't make logical sense. But that's not necessarily that. So anyway, especially since this is being videoed, I mean, to sort of maybe bring it down to like a layperson understanding, it just seems like another lobby, another pressure group, and it seems to do what lobbies do, and that's try to infiltrate their members into the offices that decide power. And also, it's sort of a two-part question, so you can respond to that. And it certainly does seem to be a political action group. If the only difference between, what we commonly understand to be a political action group or not is money, I mean, it's vetting people for the Supreme Court, right? Among other goals.
Informally, yeah.
Yeah, but I mean, it's doing it in the way that you described. It certainly seems to be political action. The other thing with regard to maybe a chicken egg kind of thing, like what precedes what, in that the Federalist Society seems to be, really just another lobby or pressure group. It sort of reminds me of lobbies or pressure groups, not necessarily with regard to funding, but like going back to the abolitionists. I mean, I have this theory that, civil rights doesn't precede economic necessity. So when it was no longer an economic necessity to have slavery throughout, what would become the entire United States, you had this group that was there to, maybe they didn't see it that way, but to take advantage of a shift in the atmosphere. Or like with feminists, I don't see that they were able to push women's rights in the workplace before it became a necessity for women, for there to be at least a two-income family to sustain the kind of standard of living that, one's parents might have had and one might hope to have. So I'm just responding in this way to sort of the chicken egg thing. To me, the revolution was the Reagan Revolution.
Right.
And so you had this group of people who was like any other lobby or pressure group, especially of a sort of intellectual nature, that now that the shift has changed, we can accelerate this change. Because I don't think we would have had the 13th, 14th, and 15th Amendment without the abolitionists and without Lincoln's death. And then you had people ready to accelerate that.
So I will say that I'm glad you brought up the Reagan Revolution. The Reagan Revolution was sort of an event that catalyzed, I would say, the organization of the Federalist Society. If you never had the Federalist Society, all the legal institutions at the time, public interest law firms, right, the people who find and finance litigation to bring to the courts, law schools, legal training programs, these were all dominated by the left. So even if you could control the political branches of government, you weren't necessarily sure you were going to get the right judges and justices when you had nominations to the Supreme Court. I mean, Reagan couldn't get Bork, so he ended up with Anthony Kennedy, who has been somewhat of a disappointment, but has also pleased the right on some issues too. So you have to make sure that you can find the right people to place on the court. And then secondly, once you have them on the court, you need to get the right kinds of cases before them. So you need to build up the legal establishment in that way. You need to have people who are going to find and finance and bring the right kind of litigation. So no matter whether or not there was this wave of counter-revolutionary sort of political movement, if you don't have what Charles Epp calls a support structure, right, for legal mobilization and legal change, you can't really get those right kinds of cases, and you have to have the right kinds of judges. So it takes both things. So I think the Federalist Society is
Aren't you kind of saying what I just said?
I'm not sure you said many things, so I'm just trying to sort of organize my thoughts. And then the second thing I want to respond to is this idea of, aren't they just another pressure group? They would be if they as an organization did anything. They don't do anything except put on conferences, meetings, and networking events as an organization. You will not see their names on any amicus briefs. You will not see them officially endorse anything. But what they do is through their meetings and educational events, they train and socialize their members, and then their members go out in their own capacity and do these things. So because it's this indirect, one step removed kind of influence, I actually don't think we have a box, a sort of social science box currently to kind of categorize their influence. Otherwise, yeah, they'd be an interest group, they'd be this, but they as an organization don't do any of that. So that was really, I think, why the epistemic community turned Penn model more accurately captures what's going on there.
Okay, with that, we come to the end. I would like to thank both of our speakers. I think
Thank you, guys.
an exceptional